This is the Ministry of Truth. I'm Gordon Comstock. This is part 6 of Woe Unto You, Lawyers by Fred Rodell from 1939, out of print. This is part 6, and it's chapter 7. Fairy Tales and Facts. Quote, "What do you know about this business?" the king said to Alice. "Nothing," said Alice. "Nothing whatever?" persisted the king. "Nothing whatever," said Alice. "That's very important," the king said, turning to the jury. Unquote. Lewis Carroll. No single fact is so essential to the life and lustiness of the legal racket as the sober pretense on the part of practically all its practitioners, from Supreme Court judges down to police court lawyers, that the law is, in the main, an exact science. No pretense was ever more absurd. The basic assumption behind the settlement of every legal dispute, whether it be settled by a judge's sacred words or out of court, is that, according to the law, there is only one right answer, one preordained answer to the problem. Lawyers and judges, so the fairy tale goes, are merely trained mechanics in the manipulation of that tremendous and complicated adding, subtracting, multiplying, dividing, and square root computing machine known as the law. They take a problem, any problem, translate it into the appropriate legal symbols, push the buttons on the big machine that correspond to those symbols, and the right answer automatically pops out at the bottom. Certainly, it is only because of their passionate belief in the machine-like and inexorable quality of the law that non-lawyers continue to submit their disputes and their civilization to legal decree. Certainly, too, the law boys themselves are anxiously aware that they must keep up the pretense if they would keep their prestige and their power. Even the Supreme Court, from time to time in its opinions, feels it imperative to state that it is the law, that infallible automatic machine, and not the court, those 9 fallible men, that really dictates decisions. For the lawyers know it would be woe unto the lawyers if the non-lawyers ever got wise to the fact that their lives were run not by the law, not by any rigid and impersonal and automatically applied code of rules, but instead by a comparatively small group of men, smart, smooth, and smug, the lawyers. Yet it should not at this point be necessary to pile up any more examples of how the law works, nor to examine in detail any more of the law's mealy-mouthed concepts and principles and elaborate logic in order to show that law is a very inexact and teeter-totter, quote-unquote, science. That none of the law's answers to problems is preordained, precise, or inevitable, and that it is indeed the lawyers with their dreary double-talk, and not the law, that mass of ambiguous abstractions, that run the show. Even if the law still be considered a big machine that gives automatic answers to legally worded questions, it is the lawyers and the lawyer judges who phrase the questions and decide which buttons to push. And anyone who has ever worked a cigarette slot machine knows that if you want Chesterfields, You push the Chesterfield button. The machine does the rest. Thus, the Supreme Court knows that if it pushes the, quote, deprivation of property without due process of law, unquote, button, the answer will come out unconstitutional. If it pushes the, quote, state police power, unquote, button, the answer will come out constitutional. But the machine of the law does not tell the court which button to push. Again, any judge engaged in deciding a dispute over an alleged business agreement knows that if he pushes the button marked offer, acceptance, consideration, and a couple of others, the answer will come out valid contract. But if he pushes the no offer button, or the no acceptance button, or the inadequate consideration button, the answer will be no contract. It is just as simple as that. The point is, of course, that in every case the real decision is made. The law of the case is laid down not after the machine gets to work, but before. The crux of the whole matter lies in the choice of which button or buttons to push, which principle or principles or concepts to follow. In Senior versus Braden, the Supreme Court decided to push the buttons marked property tax and interest in land, whereupon the machine whirred smoothly through no jurisdiction to tax and deprivation of property without due process of law, right up to the answer unconstitutional. But if the court had instead laid its venerable finger on the income tax button, or had skipped the interest in land button, the machine of the law would have whirred just as smoothly to the exactly opposite conclusion. And there are always at least two buttons, two principles between which a choice must be made. Often there are several such choices. In no law case, in no legal dispute, is such a choice not presented. Take one of the coldest, cut and dried cases imaginable. A sane man deliberately kills another man in the sight of several reliable witnesses. All of the relevant written statutes and all the principles of law which encrust those statutes seem to point toward one answer: first-degree murder. Yet, as everyone knows, some lawyer will take the killer's case, will dig up accepted and respectable principles of law, which, if followed, would declare the killer innocent of crime, and may, for it has often happened, convince the court that the right legal answer is not guilty. No wonder, then, that in less spectacular and less apparently open and shut legal controversies, a principle or series of principles can always be found to lend the benediction of the law to either side of any case. No wonder there is no such thing as a legal problem which does not have, in the eyes of the law, two sides to it, up to the point when some judge applies just one set of principles to the problem and thereby settles it, quote, according to the law, unquote. What are, then, all these abstract principles of which the law is built? These rules, so diverse and complicated and contradictory that some combination of them can be used as push buttons to obtain any result under the sun. What are these great and guiding truths that can override written statutes and even constitutions? What are these indispensable counters of all legal thinking and legal action? Where do they come from? Once the stork brought them theory that they sit in some jurisprudential sky, waiting to be brought to earth, has been dispensed with. The simple truth is that each of them originated as the out-loud cogitation of some judge slightly worried as to which old set of principles, or cogitations of other judges, to apply to the case before him, and still wanting to make his decision sound as inevitable, as automatic, as scientific and logical as possible. Every legal principle begins its existence as a rationalization, a justification. And honestly, this is why of some legal decision. And the more it is subsequently used to justify other decisions, the more respectable it grows. Legal principles, like meerschaum pipes, improve with use and age. There is a principle that equitable relief, a special kind of legal remedy, will not be granted to anyone who comes into court with quote-unquote unclean hands. It originated centuries back in the desire of some judge to bolster with a high-sounding excuse his decision for the defendant in a case in which the plaintiff seemed, at first, to have the best of the law on his side. The excuse came in handy in other cases. Today, it is a primary principle of quote-unquote equity law. So, with the principle that the states may regulate businesses, quote, affected with a public interest, unquote. A Supreme Court judge, in upholding such a regulation, once helped give his opinion an authoritative sound by stating that the business in question was affected with a public interest and consequently was properly subject to regulation. The words stuck. The rationalization became an accepted principle. Moreover, by reversing the rationalization, other judges made an even more useful and more used legal rule out of the idea that businesses not affected with a public interest are generally not subject to state regulation. So, too, with the principle that consideration is essential to a valid contract. So with the principle that Congress may not regulate industrial activities which affect interstate commerce only indirectly. So with all the thousands upon hundreds of thousands of principles of the law. Each got its legal baptism as part of the random rationalizings of some judge trying to make a specific decision sound more learned and logical to his fellow lawyers and to himself. And of course, once a principle has been accepted, or as the lawyers would call it, discovered, as part of the law, its use is no longer restricted to the kind of problem it was originally dressed up to deal with. It might be supposed that, even if the messianic mutterings of a judge in a specific case can become proud principles of the law, quoted and followed in other cases, at least the legitimate use of those principles would, in the future, be limited to the kind of case the judge was muttering about. Not at all. A legal principle, once let loose, is never restricted to its own backyard, but is allowed and often encouraged to roam over the whole field of law. Thus, a principle born of a judge's patter in settling a financial dispute between two businessmen can, like as not, become a bulwark of constitutional interpretation. A principle first mouthed to bolster up a decision in a suit for slander may later turn up as the key to the law in a murder case. In Senior versus Braden, for instance, a case centering around state taxes and the U.S. Constitution, the quote-unquote controlling principle was borrowed from a case which had nothing to do with state taxes nor with the U.S. Constitution, but involved instead a little problem of property law and of proper legal procedure under a federal statute. Not only are legal principles and concepts so vague and so abstract that they make as much sense or nonsense when applied to any of a dozen vitally different kinds of legal dispute, they are also so treacherous of meaning that the same principle can often be used on both sides of the same dispute. There is a famous legal principle which disparages, quote-unquote, interference with a famous legal concept called, quote, freedom of contract, unquote. Both the principle and the concept are genuine and typical examples of the law, in that neither comes out of any constitution or statute. They come straight out of the judges' heads and mouths. Yet in a labor dispute arising out of a strike, the workman's lawyer may well plead in court that any interference with the strike will, by weakening the workmen's bargaining power, amount to an interference with their, quote, freedom of contract, unquote, while the boss's lawyer is arguing that the strike should be stopped or crippled by legal decree because it interferes with the boss's, quote, freedom of contract, unquote. Like most legal concepts, quote-unquote, freedom of contract can mean very different things to different people, or even to different judges. Like most legal principles, the principle built on that concept means exactly nothing as a guide to the settlement of a specific controversy. The sober truth is that the myriad principles of which the law is fashioned resemble nothing so much as old saws, dressed up in legal language and paraded as gospel. When Justice Marshall intoned, quote, the power to tax involves the power to destroy, unquote, and on the basis of that principle declared that a certain state tax was illegal, he might just as well have said, quote, great oaks from little acorns grow, unquote, and founded his decision on that, except that he would not have sounded quite so impressive. Quote, the burnt child dreads the fire, unquote, could substitute for many a principle of criminal law, and, quote, waste not, want not, unquote, or perhaps, quote, a penny saved is a penny earned, unquote, would be as useful and as pertinent to the solution of a business squabble as the principle that consideration is necessary to validate a contract, all that the law is, all that it amounts to, all that it is made of, all that lawyers know and non-lawyers don't know, is a lot. A miscellaneous and tremendous lot of abstract principles. And every one of those principles is, in essence, no more than a generalized gem of alleged wisdom that some judge has spoken in order to rationalize a decision of his, and that other judges have later picked up and repeated. Moreover, even if those gems of alleged wisdom were, as usually they are not, relevant and reasonable justification for deciding a legal problem one way or the other, there would still be the same old catch in the whole procedure. For the gems, as well as being so generalized, are so many, so motley, and so confusing. And the catch comes in matching the right gem or gems, the right set of principles or principle, to any given set of specific facts. That is the crucial step, the key move in the settlement of any legal dispute. That is the move that the prestidigitators of the law always make behind their backs, no matter how vigorously and triumphantly they may later flaunt the principles they have picked. That is why the law not only is not an exact science, but cannot be an exact science, so long as it is based on abstract principles and deals with specific problems. You note in this, by the way, this book is, he's talking about the Babylonian law, not the Mosaic Code. You notice that? Look how useless and vague and phony is the Babylonian law system. Okay, back to the book. Just as the devil can always cite Scripture to his purpose, so can any lawyer on either side of any case always cite the law to his. As would, of course, be expected, any lawyer will rise to the defense of his trade and hotly dispute all this disparagement of the law's vaunted dignity, majesty, and preciseness. He will tell you that most legal principles, though abstractly phrased, have acquired, through long usage, a specific content of meaning and application, in lawyers' and judges' minds at least. He will tell you that the law must have two qualities, continuity and certainty, parenthesis. He will not put it that the law must seem to have continuity and certainty in order to survive, in parenthesis. He will tell you that in order to achieve continuity and certainty, the law must be based on general or abstract principles which can be carried over from one year to the next and from one decision to the next. And he will tell you, if you press him about the way in which abstract principles can be carried over continuously and certainly, that problems and fact situations, by reason of their similarity or dissimilarity, fall naturally into groups. One group will be governed by one legal principle, another group by another, or possibly a contradictory principle. In short, each new case or problem that comes up is enough like some batch of cases or problems that have come up before to be controlled by the same principle that was used to control them. This is your certainty. There is your dignity, majesty, and preciseness. In the abstract, and coming from a lawyer, it is, of course, abstract, it makes a pretty theory. There are a few practical matters, though, that it does not explain. It does not explain why, if there is a quality of certainty about the law, dependent in part on the fact that legal principles acquire a specific content in lawyers' and judges' minds, why so many hundreds of thousands of law cases seem to keep coming to court with full-fledged lawyers arguing on opposite sides. Nor, if it be said that some lawyers just don't know the law as well as they should, does the theory explain why the lower courts are constantly being reversed by the appellate courts, nor why there are so many dissenting opinions, nor how it happened that 57 of the nation's top-ranking lawyers were unanimously wrong in advising their clients about the Wagner Labor Act. The theory does not explain either why a promise by a stranger to give money to the same church is more like a cigarette than it is like a promise by a stranger to give a present to the same girl. For the first two, remember, are valid considerations for a contract, while the third isn't. My guess there that Fred Rodell doesn't write about, let's see, this was written in 39. A lot of churches had become incorporated by then, so my guess would be that the church was incorporated, and the state is always going to look out for its own, and the incorporated church is a puppet of the state. So, sure, they're going to stick up for the church, the incorporated church getting their money. I don't think Rodell knows about that, maybe. I don't know. Back to the book. Nor does the theory explain why the tax problem of Senior versus Braden fell naturally into the same batch of cases that included the Brown versus Fletcher problem in legal procedure, and so was controlled by the same general principle. Still, it makes a pretty theory in the abstract. The joker in the theory is the assumption that any two, much less 20, fact situations or legal problems can ever be sufficiently alike to fall naturally, that is, without being pushed, into the same category. The very existence of two situations or problems means that there are differences between them. And here, perhaps, the lawyer defending his craft may pop up again to say that the differences can be major or minor, important or unimportant. It is when the quote-unquote essential facts are the same, he will tell you, that the same general principles apply. But which facts in any situation or problem are quote-unquote essential, and what makes them quote-unquote essential? If the essential facts are said to depend on the principles involved, then the whole business all too obviously goes right around in a circle. In the light of one principle or set of principles, one bunch of facts will be the quote-unquote essential ones. In the light of another principle or set of principles, a different bunch of facts will be quote-unquote essential. In order to settle on the right facts, you first have to pick your principles, although the whole point of finding facts was to indicate which principles apply. That sounds like a Darwinist telling you the world was billions of years old. Or well, we date the bones, we date the fossils by the sediment. Well, how do you date the sediment? Well, we date the sediment by the bones we find. Circular reasoning. Okay, the lawyers and judges do it too. Well, we determine the principles by what the essential facts are, and we determine the essential facts in terms of what the principles are. Oh, classic. Yet if the quote-unquote essential facts do not hinge on the principles involved, then somebody must pick the essential facts of any situation from the unessential ones. Who? Well, who but the lawyers and the judges? And the picking of the essential facts, which are going to determine the quote-unquote similar group of old cases, which group, in turn, is going to determine the appropriate legal principles, then becomes as arbitrary and wide open a choice as if the lawyers or judges had just picked the appropriate principles to begin with. Suppose, to take a simple example, a man driving a 1939 Cadillac along the Lincoln Highway toward Chicago runs into a Model T Ford. This is 1939. Some of this stuff is so dated. Fabulous. But then again, what he's saying about lawyers is timeless. Model T Ford, driven by a farmer who has just turned onto the highway from a dirt road and demolishes the Ford, but does not hurt the farmer. The farmer sues, and a local judge, on the basis of various principles of law, which are said to control the case, awards him $100. A week later, another man, driving a 1939 Cadillac along the Lincoln Highway toward Chicago, runs into a Model T Ford driven by another farmer who has just turned onto the highway from the same dirt road and demolishes the Ford but does not hurt the farmer. This farmer also sues. The facts, as stated, seem to make this case quite similar to the previous case. Will it then fall into the same group of fact situations? Will it be controlled by the same principles of law? Will the second farmer get $100? That all depends. For of course there will be other facts in both cases. Some may still be similar. Others inevitably will be different. And the possibilities of variation are literally endless. Maybe the first Cadillac was doing 60 miles an hour and the second one 30. Or maybe one was doing 45 and the other one 40. Or maybe both were doing 45, but it was raining one week and clear the next. Maybe one farmer blew his horn and the other didn't. Maybe one farmer stopped at the crossing and the other didn't. Maybe one farmer had a driver's license and the other didn't. Maybe one farmer was young and the other was old and wore glasses. Maybe they both wore glasses, but one was nearsighted and the other farsighted. Maybe one Cadillac carried an out-of-state license plate and the other a local license plate. Maybe one of the Cadillac drivers was a bond salesman and the other a doctor. Maybe one was insured and the other wasn't. Maybe one had a girl in the seat beside him and the other didn't. Maybe they both had girls beside them, but one was talking to his girl and the other wasn't. Maybe one Cadillac hit its Ford in the rear left wheel and the other in the front left wheel. Maybe a boy on a bicycle was riding along the highway at one time, but not the other. Maybe a tree at the intersection had come into leaf since the first accident. Maybe a go slow sign had blown over. The point is, first, that no two fact situations anywhere, anytime, are entirely similar. Yet a court can always call any one of the inevitable differences between two fact situations, no matter how small, a difference in the quote-unquote essential facts. Thus, in the second automobile accident, any one of the suggested variations from the facts of the previous accident might or might not be labeled essential. And a variation in the essential facts means that the case will be dumped into a different group of cases and decided according to a different legal principle or principles. When the second accident case came to court, the judge might call entirely irrelevant the fact that a caution sign along the highway had blown down since the week before. Or he might pounce on that fact to help him lay the legal blame for the smash-up, not on the Cadillac driver this time, but instead on the farmer, or on both of them equally, or on the State Highway Department, according, of course, to accepted principles of law. Moreover, the mere fact that one driver was doing 45 miles and the other 40 might easily be enough to induce the judge to distinguish the second accident from the first accident and group it instead with a bunch of cases involving railroad trains that had run over stray horses and cows. The essential facts being similar, the judge would put it, the same principles of law are controlling. As with the two automobile accidents, so with any two legal disputes that ever have come up or could have come up, except that most legal disputes are far more complicated, involve many more facts and types of facts, consequently present the judges with a far wider selection from which to choose the essential facts, and so open up a much greater range of legal principles which may be applied or not applied. And since no two cases ever fall naturally into the same category, so that they can be automatically subjected to the same rules of law, the notion that 20 or 30 or 100 cases can gather themselves unshoved under the wing of one controlling principle is nothing short of absurd. Yet the embattled lawyer may have one final blow to strike in defense of the law and its principles and its supposed certainty. The law, he will tell you, is concerned with a great deal more than the problems that actually get into court and are settled by judges. The law is chiefly concerned with maintaining a constant code of rules and behavior under which men can live and handle their affairs and do business together in a civilized manner. Only the freak situations, the rare situations, ever develop into law cases, he will tell you. For the most part, men's affairs run smoothly and certainly along, without litigation or legal squabbles, under the trained and watchful and paid guidance of the lawyers and their law. For instance, he will go on, of all the many business contracts and legal agreements of every sort that are drawn up and signed every day, only a very small fraction are eventually carried into court. Bond issues, sales contracts, insurance policies, leases, wills, papers of every kind. All these are in constant use, yet comparatively rarely do they become the center of a legal dispute. Parenthesis. And notice, incidentally, how claims concerning the certainty of unlitigated law always seem to stress its use in business dealings and commercial affairs. End parenthesis. Why do so few legal documents end up in court cases? Simply, the lawyer will tell you, because they are drawn up and phrased by lawyers in accordance with the law and in the light of recognized legal principles. That is what makes them safe and sure and workable, and what keeps the people with whose affairs they deal from constantly going to court about them. And that is where the certainty of the law really comes in and really counts. Well, don't you believe a word of it. In the first place, those legal papers of all kinds and descriptions are phrased the way they are, not in order to keep the people whose affairs they deal with out of court, but in order to give somebody a better chance of winning if the affair gets into court. If the document is an installment plan contract, or a lease, or an insurance policy, or a mortgage, you can guess who that somebody is. If it is the result of a really two-sided business dicker, with lawyers working for both sides, then some of the clauses of the contract will be for the benefit of one side and some for the other, in case they go to court over it. At any rate, every legal agreement is drawn up in contemplation of a court fight. It is therefore phrased with an eye to the same old ambiguous abstract principles that the judges use for law. Gee, it sounds like he's describing the United States Constitution written by the founding lawyers of the country. Wow. The corporate contract that kept us enslaved to the King of England, and more specifically the Bank of London, and more specifically, you know, the only entity higher than that. You should know. Continuing. And no matter how hard the lawyers may try to make their legal language favor one side or the other, they can no more wring certainty out of abstractions than they could wring blood out of a cauliflower. That's interesting. What he's saying there about lawyers is there's a page or two in the book The Iron Heel by Jack London, where Jack London makes the same observations about lawyers, very similar. How they work so hard to write these contracts and make them airtight, And then there's no way you can, though. And then the other lawyer knows how to make it unairtight, how to crack the code so easily, and it goes back and forth, and it's just a game that the lawyers play with one another at the expense of the non-lawyers. Jack London made that observation in The Iron Heel. Continuing, but there is a far more important reason why the lawyer is dead wrong when he claims that legal advice and guidance keep most business arrangements and affairs out of court. People do not go to court over their mutual dealings simply because their contracts are unlegally or uncertainly worded, and they do not keep out of court simply because the relevant documents are drawn up in the approved style. A man who is convinced that he is getting a raw deal, or that the other side is not living up to its bargain, or who is just dissatisfied with the way the whole arrangement is working out, will just as likely take his troubles to court, though the papers involved had been prepared by a special committee of the American Bar Association. And he will find a lawyer to take his case too, and support it with accepted principles of law. Most business transactions, however, run off smoothly of their own accord. Both sides, more or less, live up to their promises, and neither side feels aggrieved or cheated. This is just as true, moreover, even though the relevant documents be written in execrable legal taste. And, very briefly, it is this fact, not the fact that lawyers are always hovering around, advising and charging fees, that is responsible for the small percentage of business affairs that find their way into a courtroom. As a matter of fact, the lawyers, with their advice and their principles and their strange language, no doubt increase instead of decreasing the number of transactions that end up in dispute and litigation. That's exactly what happens to churches when they incorporate. The Judas goat lawyers. And what did Jesus say about lawyers? The lawyers tell them, oh, churches, you need to protect yourselves. You need to incorporate. And all that does is open the church to more litigation, to make the church more susceptible, much more susceptible to litigation, because the church is a corporation and its creator is the state. And it's got to abide by the shifting sands of public policy. Continuing, if lawyers would let men carry on their affairs and make their agreements in simple, specific terms, and in words intelligible to those involved, there would be fewer misunderstandings and fewer real or imagined causes for grievance. Moreover, to jump to another legal field, if written laws, statutes, were worded in plain English, instead of being phrased by lawyers for lawyers, there would unquestionably be fewer cases involving the interpretation of those statutes and the question whether they do or do not apply to various specific fact situations. No, the asserted certainty of the law is just as much of a hoax out of court as it is in court. And how could it not be, inasmuch as the whole of the law whether it be glorified in the opinion of a Supreme Court justice, or darkly reflected in the conversation of two attorneys about to draw up a deed of sale, is built of abstract principles and nothing more? There is an old tale that is told of 3 men who were walking through a wood when they came upon a tremendous diamond lying on the ground. All of them had seen it at the same instant, and yet, clearly, it could not be divided between them. They were peaceful men, and so, rather than fight over its possession, they determined to present their claims in a logical fashion. "You will recall," said the first man, "that as we approached the spot where the diamond lay, we were walking not in single file, but abreast. The 2 of you were on my left, and that fact is of utmost importance, for as neither of you, I am sure, would care to deny, the right must always prevail. Therefore, the diamond is clearly mine." "Indeed," said the second man, "I should not care to deny that the right must always prevail. But you have omitted in your brief summary of the situation one highly significant point. It is the diamond, after all, which is the crux, the center, the whole sum and substance of our problem. And from the standpoint of the diamond, it was I who was on the right, and who must therefore prevail." "You are both very clever," said the third man, "but your cleverness, I fear, has undone you. Observe that first one of you, who walked on one side of me, and then the other, who walked on the other side, has claimed he was on the right. I, too, will grant that the right must always prevail. Yet it is, I believe, an accepted truth that in any contest between 2 extremes, the middle ground is likely to be, in fact, the right one." It is not told which of the men got the diamond, and it does not much matter. They must have been lawyers. Okay, I'm Gordon Comstock. This is the Ministry of Truth. You've been listening to part 6 of Woe Unto You, Lawyers, by Fred Rodell from 1939. It's out of print because you're not supposed to know this stuff. Later.